Hello viewers, Supreme Court Associate Justice Clarence Thomas might also have damaged the regulation by means of refusing to recuse himself from a high-profile Supreme Court case, in accordance to prison pupil Lawrence Tribe. But before we proceed, if you are new to my channel, please kindly take a moment of your precious time to hit the subscribe button and hit the notification bell for latest updates from us. Tribe, Professor Emeritus at Harvard University, instructed MSNBC's Lawrence O'Donnell that Thomas may additionally have violated 28 U.S. Code 455 due to the fact he has now not disqualified himself in Moore v. Harper, a controversial case about the strength to draw and strike down electoral maps. The statute stated through Tribe offers with federal judges disqualifying themselves from instances, and he argued that Thomas used to be in violation of the regulation due to the fact of two provisions that nearly any attorney would say require Clarence Thomas no longer to take part at all. One of them says that a justice, and it particularly applies to Supreme Court justices, may now not take part if any individual should fairly query that justice's impartiality, Tribe said. Clearly it is the case here, he said, and he additionally stated an area that says a justice mustn't be worried if their partner has an activity in the case. It's apparent that Ginny Thomas has an interest, Tribe said. She used to be a lively participant in the strive to use something like the impartial kingdom legislature concept that used to be earlier than the courtroom on the argument on Wednesday, and Clarence Thomas fortunately participated anyway. In Moore v. Harper, North Carolina, Republicans are asking the Supreme Court whether or not country courts have the prison authority to throw out electoral maps and order districts to be redrawn. The justices are thinking about the so-called independent state legislature theory, which holds that courts do no longer have the strength to strike down maps drawn through nation legislatures. The consequence of the case ought to have a profound impact on U.S. elections, with the Brennan Center for Justice beforehand calling Moore v. Harper an enchantment, advocating for severe interpretation of the Constitution that should make it simpler for kingdom legislatures to suppress the vote, draw unfair election districts, allow partisan interference in ballot counting. Thomas's wife, conservative activist Virginia Ginny Thomas, has been the middle of controversy over her conversations with former White House Chief of Team of Workers Mark Meadows. Tribe stated that Clarence Thomas's questions had been pointed and that he tried to lure the defenders of a Democratic strategy to this through his questioning. However, Tribe stated the statute on recusal used to be very challenging to put in force, and he doubted the Department of Justice would take any action. O'Donnell requested Tribe about implementing the statute in query, and Tribe mentioned that it used to be now not successfully enforced, even although it applies to Supreme Court justices. He stated 28 U.S. Code 455 says it shall be illegal for a justice to do what it appears that Clarence Thomas, as a Supreme Court justice, has done. People who suppose these guidelines do not follow to justices are wrong, Tribe went on. They apply. That regulation applies. It makes use of the phrase justice, and the solely judges in the federal device who are justices are the 9 that we see all the time sitting in the Marble Palace. What is your opinion about this video? Please drop your comments below, and thanks for watching.